Kidnapping defenses vary based on the details of the case, as kidnapping is one of the most serious criminal charges a person can face in Rogers County. The word kidnapping often makes people think of extreme situations involving strangers, ransom demands, or someone being taken far away. However, Oklahoma kidnapping allegations can arise from many different facts. What is kidnapping in Oklahoma? In general terms, kidnapping involves unlawfully seizing, confining, abducting, decoying, or carrying away another person without lawful authority and with the required criminal intent. Depending on the facts, prosecutors may claim the accused intended to confine the person against their will, remove the person from a location, or hold the person for some unlawful purpose. The exact charge matters. Oklahoma law also recognizes related offenses such as abduction, child stealing, kidnapping for extortion, and other crimes involving restraint or transportation. Each charge has distinct elements, and the defense should focus on the specific statute the state filed under. The state must prove every element. One of the most important defenses in a kidnapping case is the requirement that the prosecution prove every element of the charge. The state must do more than show that an argument occurred or that one person felt uncomfortable. Prosecutors must prove the accused unlawfully restrained, confined, moved, or abducted another person and acted with the intent required by law. If the evidence is unclear, inconsistent, exaggerated, or unsupported by physical proof, reasonable doubt may exist. Consent can be a powerful defense in many kidnapping cases. If the alleged victim voluntarily entered a vehicle, stayed in a home, traveled with the accused, or agreed to remain in a location, the state may have difficulty proving unlawful confinement or abduction. Consent cases often turn on text messages, call logs, witness testimony, surveillance footage, prior relationship history, and the parties' conduct before and after the alleged incident. If the alleged victim had opportunities to leave, communicated freely, or acted voluntarily, those facts may support the defense. Lack of intent. Kidnapping requires more than confusion, poor judgment, or a heated argument. The state must prove the required criminal intent. If the accused did not intend to confine, abduct, carry away, or unlawfully restrain another person, the charge may not fit the facts. For example, a person may drive away during an argument without realizing the passenger wanted to get out. A parent may misunderstand a custody schedule. A person may block a doorway briefly during an emotional conversation without intending to kidnap anyone. These facts may still raise legal concerns but may not support a kidnapping conviction. Lawful authority. Oklahoma kidnapping law requires the accused to act without lawful authority. In some cases, the defense may argue that the accused had legal authority or a good faith basis for their actions. This issue may arise in parental disputes, guardianship situations, law enforcement encounters, school or childcare matters, medical emergencies, or situations where a person acted to protect someone from immediate harm. Lawful authority does not apply in every case, but when it does, it can directly challenge an essential element of the prosecution's case. Parental and custody-related defenses. Kidnapping allegations sometimes arise during custody disputes. A parent may be accused of wrongfully keeping a child, failing to return the child on time, taking the child to another location, or withholding visitation. These cases can be complicated because criminal law and family law may overlap. Important questions may include whether a custody order existed, what the order required, whether the accused had legal custody or visitation rights, whether the other parent consented, whether there was an emergency, and whether the accused acted maliciously, forcibly, or fraudulently. A custody disagreement should not automatically become a kidnapping conviction, but violating a custody order can still create serious legal problems. No force, threat, or restraint. Some kidnapping cases are weaker because the evidence does not show force, threats, restraint, deception, or meaningful confinement. A person who is free to leave, free to call for help, or voluntarily remains in a location may not have been kidnapped. This defense may rely on evidence of unlocked doors, available transportation, phone access, comm communications, witnesses who saw no restraint, or video showing the alleged victim moving freely. Mistaken identity. In some cases, the wrong person is accused. Kidnapping allegations may arise from chaotic events, poor lighting, intoxication, fear, or unreliable witness identification. The defense may challenge whether the accused was actually the person involved. Surveillance video, phone location data, receipts, employment records, witness testimony, and digital communications may establish where the accused was and what actually happened. False or exaggerated allegations. Kidnapping accusations may sometimes be exaggerated during domestic conflicts, custody battles, breakups, family disputes, or efforts to gain leverage in another case. That does not mean every allegation is false, but it does mean the defense should carefully investigate motive, timing, prior inconsistent statements, and objective evidence. Text messages, social media posts, prior threats, protective order filings, custody pleadings, and witness statements may reveal whether the allegation is reliable. Constitutional violations. Kidnapping investigations may involve arrests, searches, phone seizures, vehicle searches, home entries, interrogations, and recorded statements. Police must follow constitutional rules when gathering evidence. If law enforcement violated the accused's rights, the defense may seek to suppress evidence or statements. Important issues may include whether officers had probable cause, whether a search warrant was valid, whether the accused was properly advised of rights before custodial questioning, and whether any statement was voluntary. Lesser included or alternative charges. Sometimes the facts alleged by the state may support a lesser charge but not kidnapping. Depending on the facts, prosecutors may overcharge a case that is closer to domestic assault, assault and battery, interference with custody, unlawful restraint, threats, or another offense. A defense attorney may argue that the state's evidence does not satisfy the heightened elements of kidnapping. This approach can be important in negotiations and at trial. Evidence that may help the defense. Helpful evidence in a kidnapping defense may include text messages, phone records, GPS data, surveillance video, 911 recordings, body camera footage, witness testimony, custody orders, prior communications, photographs, social media messages, hotel records, receipts, medical records, and evidence showing the alleged victim's ability to leave or communicate. Because evidence can disappear quickly, early investigation matters. Videos may be deleted, phones may be replaced, witnesses may move, and memories may fade. Do not contact the alleged victim. If you have been accused of kidnapping, do not contact the alleged victim to explain, apologize, argue, or ask them to drop the case. There may be a protective order, bond condition, or no contact order in place. Even if no order exists, contact may be misunderstood and used against you. Allow your attorney to handle communication through proper legal channels. Kidnapping charges in Rogers County require immediate attention. The defense may involve consent, lack of intent, lawful authority, custody rights, mistaken identity, false allegations, insufficient evidence, or constitutional violations. The right strategy depends on the exact charge and the facts surrounding the accusation.